J'ouvre maintenant la
I call this meeting to order. Welcome to meeting number 40 of the House of Commons Standing Committee on Transport, Infrastructure and Communities. Pursuant to Standing Order 1082 and the motion adopted by the committee on Thursday, February 3rd, 2022, the committee is meeting to study air passenger protection regulations.
aujourd'hui.
Today's meeting is taking place in a hybrid format pursuant to the House Order of November 25th, 2021. Members can attend in person or by using Zoom.
Appearing before us today, we have, as an individual, Mr. John Granick, Faculty Lecturer and Academic Programs Coordinator, School of Continuing Studies, McGill University, by video conference. Air passenger rights, we have Mr. Gabor Lukács, President. From Late Flight Claim Canada, nous avons Mr. Jacques Bonneau, Président. From Option Consommateur, nous avons Madame Sylvie de Bellefeuille, Lawyer, Budget and Legal Advisor. And from Public Interest Advocacy Centre, we have Mr. John Lawford, Executive Director and General Counsel. I'd like to take this opportunity to inform members that all of today's video conference witness participants have completed the necessary audio-visual checks. And I'm just going to look over to our translators right now, get a big thumbs up, make sure everything's good. Perfect. We will now begin the opening remarks with Mr. John Granick for 5 minutes. Sir, the floor is yours.
Thank you very much. I'd just like to thank the members of the House Committee to having invited me to speak to you today on the air passenger protection regulations. Today, I would like to address the issue of compensation, primarily due to air travelers as a result of an airline's decision to disrupt a passenger on the itinerary, and to provide you with my recommendations to address what I see are current shortcomings within those regulations. But first, let me quickly walk through the history of that regime to make sure that we have the right context into which I will then talk about my recommendations. So in May of 2019, we had the introduction of the air passenger protection regulations that stipulated certain minimum airline requirements for air travel, including things like standard treatment and, in some situations, compensation for passengers. These regulations were the result of extensive consultation with stakeholders in the commercial air travel industry, including airlines and consumer groups. And these new regulations set out obligations to passengers in communication, delayed or canceled flights, denied boarding, tarmac delays, and transportation of musical instruments, among others. These regulations were instituted by the Canadian Transportation Agency under the Canada Transportation Act, as amended by the Transportation Modernization Act. They were to be administered by the Canadian Transportation Agency and came into effect progressively through December 15th of 2019. And these regulations apply to all flights to, from, and within Canada, including connection flights. One of the more contentious provisions in these regulations has been the ones concerning delayed or canceled flights. And my comments and observations today will focus on what I see as a definition of airline control, and the interpretations that various stakeholders have taken of the airline control statement. So when you talk about the way in which the APPR basically has delineated scenarios, primarily there's one provision in there that seems to have been causing the most grief, which is things that are in airlines control but are required for safety purposes. And based on that provision and those scenarios, passengers are exempt from compensation. It appears disruptions in this characteristic have raised the ire of many travelers and consumer groups, claiming that airlines have been misusing this characterization to escape the compensation requirements of disruptions within airlines control. So when we talk about what are some of those situations that are dealing with situations where airlines are claiming safety, we're talking about situations that are dealing with situations regarding maintenance and regarding staffing. And when we in fact have those situations, the airlines are obligated only to provide a standard level of treatment and the completions of passenger itinerary and no compensation. The compensation, of course, does vary depending on the type of delay and the length of delay, ranging from anywhere from $400 for a 3-hour delay to up to $1,000 for a delay of over 9 hours. I've made some simplifying assumptions in terms of how these conditions and how these regulations came into place. I'm pretty sure that there were a significant amount of consultations going on with the airlines specifically and with the consumer groups, and I'm pretty sure there was agreement among all of these stakeholders that these regulations were in fact fair and could be applied readily. However, it's become very apparent, and situations have now been overwhelmingly in situations where airlines now are looking at airline control within safety as being a primary cause for not paying compensation. Typically, what the airlines do in terms of designing their flight schedules, the resources required to fly that schedule, be they physical, human, or financial, deployed from established inventory and reflect the need to have the required resources at the moment the flight is scheduled to operate. Airline staffers recognize that absences, shortages are a matter of course. Things like vacations, leave of absence, retirement, sicknesses are all part of the way in which staff are deployed. Planners already take into account the fact that these absences will be there by looking at creating reserves. And reserves are typically there for flight attendants and for pilots. And these reserves are deployed at the instance when staffing shortages are apparent, even within a day of flight. The number of airline employees that the airline says are reserve staff is very much at the airline's discretion. If the reserves are low, absences are high, flights are delayed, flights are canceled. And welcome to 2022. Absences can be forecasted based on historical absences, and the reserve levels do not reflect the realities of the 2022 absences. While the CTA did express the opinion that staffing levels are not grounds for delays to fall outside the airline's control, airlines continue to basically make such claims and have in fact gone to federal court. Both Air Canada and WestJet have gone to federal court looking for further exemptions from these regulations based on scenarios that they say are part of the Montreal Convention, that these regulations are flying in the face of the ICAO Montreal Convention. So this leads me to submit that, that we need to overhaul these exemptions, that, the rules by which airlines can basically deny compensation really need to be addressed quickly. And we have some models, that we don't have to reinvent things from scratch. But my belief is that the European Union's regulations on compensations are probably in better condition than the Canadian ones. The outline, the rules in the European Union.
Thank you very much, Mr. Graddick. Unfortunately, I'm going to have to cut you off there. I tried to give you a little bit of leeway, but you will be submitting that, so we will have it on record. Next, from Air Passenger Rights, we have Mr. Lukács. Mr. Lukács, the floor is yours. You have 5 minutes.
Mr. Chair, honorable members, Air Passenger Rights is Canada's independent non-profit organization of volunteers devoted to empowering travelers. We take no government or business funding, and we have no business interest in the travel industry. We speak for passengers whom we help daily in their struggle to enforce their rights. Back in 2017, we cautioned that the government's proposal would not adequately protect Canadian passengers and fall short of the rights provided by the European Union's regime. We thank you for the privilege to testify before you again and assisting you in taking stock of the Air Passenger Protection Regulations known as the APPR and its many shortcomings. Mr. Darrell Pink, a small claims court adjudicator, held that, quote, when consumer protection is the intended outcome of a regulatory regime, it should be assumed the regime will be in plain language, easy to understand, and support a simple claims process. The APPR, which was intended to accomplish enhanced passenger rights, accomplishes none of these, end of quote. Mr. Pink was correct. Let's look at some examples. Mia and Joel paid good money for their tickets on an Air Canada flight to Vancouver. Yet when they presented themselves for check-in, they were denied boarding. The airline's agent mistakenly believed that Mia and Joel did not meet some travel requirements. As a matter of fact, they were both eligible to travel. Common sense dictates that they should have received denied boarding compensation. Indeed, in the European Union or with an EU carrier, Mia and Joel would have received denied boarding compensation. In Canada, however, they got nothing because the APPR provides for compensation only to passengers denied boarding due to overbooking and not for any other reasons. Mia and Joel's experience highlights that the APPR's terminology does not reflect common sense. We recommend that Canada adopt the EU's common sense definitions for denied boarding and cancellation. Alex booked a round-trip ticket for a weekend getaway leaving from Canada to Boston on Friday afternoon and returning from Boston on Sunday afternoon. On Friday, Alex's flight to Boston was canceled due to a snowstorm, which is clearly outside the carrier's control. The airlines offered to rebook Alex on a flight departing Canada on Sunday morning, rendering his travel devoid of any purpose. By the time Alex would arrive in Boston, they would have to check in for their return flight. Alex works 5 days a week, like many Canadians do, and cannot defer the return flight until Tuesday. Had Alex's canceled flight been departing from Boston or Paris, Alex would have had no difficulty obtaining a full refund under the US or the EU rules. But Canada's APPR, as amended this past September, offers Alex no protection. Why? Because the airline offered a flight departing within 48 hours of Alex's original departure time. We recommend that Canada harmonize its flight refund rules with the United States and the European Union. And now let's look at Lisa and Owen, who were booked on Air Canada and WestJet respectively. They had the all too common experience of their flights being canceled due to crew shortage. The airlines sold them and many others tickets without first ascertaining the availability of crew for operating the flights. When the airlines refused to compensate them under the APPR, the CTA ordered the airlines to pay. But the airlines then took Lisa and Owen to the Federal Court of Appeal. The airlines say before the court that first, it is not the airline, but the passenger who has to prove facts relating to the flight cancellation's circumstances. And second, canceling flights for a crew shortage is for safety purposes, and no compensation is owed to the passengers under the APPR. In the European Union, passengers do not have to defend against such absurdities. The EU regime is clear that it is the airline that has to prove extraordinary circumstances to avoid liability, and that safety purposes is not a universal excuse. You recommend that Canada adopt the EU's clear language on burden of proof and remove the frequently abused safety purposes excuse for not compensating passengers. We implore you, the lawmakers, to grant Canadians the same rights and protections that European passengers have been enjoying for more than 15 years. Thank you.
Thank you very much, Mr. Lukács. Prochainement, nous avons...
Next, we have Mr. Charbonneau. Mr. Charbonneau, you have the floor for 5 minutes. Hello. I'm the co-founder and CEO of a law firm dedicated to helping consumers obtain compensation for problems with their air carrier. I would like to thank the committee for inviting me. Today, you've asked us to identify the shortcomings to the RPPA and improvements that could be made. We'll talk about this later, but we think it's important to have a broader view. We have to think of the entire system that is broken. Making access to justice and access to compensation is almost impossible for travelers, and let me explain to you why. First of all, there's too much room for interpretation in terms of cases, and the respect of the rules is left to the goodwill of the carriers. You can have the best of rules and regulations, but if they're not followed, they're useless. Unfortunately, behavior of carriers has shown us that the system doesn't work. The system makes it so that it's more advantageous for them not to facilitate access for compensation, and that it's much more advantageous to refuse requests and invoke all kinds of reasons. It's not typical in Canada, but it's still generalized throughout the industry. For example, in the United States, the Department of Transportation has just emitted fines of up to $7 million for slow-walking refunds. This money is owed to passengers. There are more processes in place in Canada that favor bad behavior. The rule, with its 3 types of events, leaves too much space for interpretation. For example, attributable to the carrier, attributable but necessary for safety reasons, or not attributable to the air carrier. Too often, carriers include anything and everything without giving any detail. For example, there was an example where the pilots had miscalculated gas, and they needed more gas, this was listed as necessary, attributable to safety reasons. Yes, it's necessary, but this is an operational decision. We can also think about shortages of crew that have affected travelers this year. But it's clearly stated that this is something that is in the carrier's control. But they were said that this was a security issue. Carriers, through their requests, we can talk about rates. In section 105F, that says that carriers inaudible to the interpreter. This misinformation, combined with the practices of carriers, has the effect of leaving the passengers in their limiting traveler rights. There's an article that was published this weekend that says that in News 24, 2 passengers, a couple, one got compensation and the other one was told that they were not allowed to have compensation. Meanwhile, they were traveling on the same flight. Knowing that passengers are usually not well educated about their rights and are unable to face large companies that have access to specialized lawyers. Most passengers won't go any further after a first refusal of the carrier, and therefore their rights are violated. If a passenger decides to appeal the carrier's decision, the CTA takes up to a year or 2 and are not efficient. There are 3 types of services that are offered by the CTA. Facilitation, which is usually where passengers are sent. There is little or no validation of facts. Only the airline carrier's statements are repeated. There's no obligation to provide evidence. Through mediation, there is no obligation to provide evidence. And then there's a formal procedure where people have to wait for more than a year. People have to invest more or less than 10 hours plus analysis of answers. And then the decisions apply only to the concerned passengers. No one obligates them to contact all of the passengers that have the same situation. For example, people who are not able to fly because of crew cancellations. Let's talk about Denmark. Requests are simplified, supporting documents are necessary, facts are verified, and then there are enforceable decisions that are rendered within 6 months. The first line of treatment has much more power here. To summarize, passengers are being told anything. They have to represent themselves. There's a low rate of contestation. It takes a year or 2 to get the same answer without any obligation to verify facts. So we're encouraged bad practices and the travelers are penalized. So we're asking the committee to review the procedures in place, the role of the CTA, and to be more proactive, to have a better first-line response, to review the delays to treating complaints and force air travelers to remove clauses that state that passengers have to represent themselves and to align policies with the EU. So there have to be exceptional circumstances to deny compensation, and they have to justify it. Obligate to provide material proof in case of refusals, and expand denied boarding to more than just overbooking. For example, if there's a mistake on someone's name or they have a problem with the check-in with the airline. Thank you. Thank you very much, Mr. Charbonneau. Next, we have Ms. de Bellefeuille. Madame de Bellefeuille, you have the floor for 5 minutes. Thank you, Mr. Chair. Thank you to the committee for inviting us and to allow us to present our comments today. I'm a lawyer at Option Consommateur for 12 years. It was created in 1983. It's a nonprofit organization whose mission is to help consumers defend their rights. We receive thousands of requests for legal information every year from people experiencing difficulty with merchants including in the travel industry. Since the beginning of the pandemic, the problems experienced by air passengers have highlighted the flaws in the regulations that aim to protect them. For this reason, the APPR was recently amended to clarify the rights that passenger has to be reimbursed even if the flight cancellation or disruption is beyond the control of the air carrier. However, the chaos that we experienced in Canadian airports this summer, and particularly in Montreal, has made Canada an international laughingstock, and it's proven two things. One, customer satisfaction is not a priority for airlines. And two, regulations do not provide adequate protection for passengers. Also, the high number of complaints received by the Transportation Agency, which we believe is only the tip of the iceberg, demonstrates the current regulations being too difficult to enforce. Here's what we propose in terms of improvements. In the event of a flight delay or cancellation, the level of responsibility that carriers must assume depends on their level of control over the situation. While this is theoretically logical, it poses a problem in practice. Indeed, it is the passengers who bear the burden of obtaining justice by claiming compensation from the carrier. To do this, passengers depend entirely on the information provided by the carrier. However, this is a conflict of interest for the carrier. When the reason for the disruption is within the carrier's control, the carrier must pay the passenger a compensation, and it's a high cost. So it's in their best interest not to do this. This is the case that we observed when flight disruptions this summer were blamed on the pandemic, and that way they didn't have to make compensation. So the pandemic was footing the bill for this. It is then up to the passengers to prove that the regulation was not properly applied. Again, this makes no sense. This burden should be reversed. We also think that the payment of the compensation should be automatic, as it is the case now with overbooking. Now, when a flight is delayed or cancelled for reasons that are beyond the air carrier's control, the carrier's primary obligation is to offer an alternate flight within 48 hours. If it's not possible, then the passenger can request a refund. But this delay is far too long. There are some situations where such a delay will make the trip lose its purpose. Think, for example, of a person who bought a ticket to take a cruise and they literally missed the boat. Regulations should allow passengers to choose to receive a refund if the delay jeopardizes the reason for their trip. On another note, let's talk about overbooking. It's clear to us that this is really, it goes against the basic principles of contract law. When you buy a product or service, the carrier has the obligation to provide that service, which is to carry a person from point A to point B. The problem with overbooking is that we allow the carrier not to provide that service to certain passengers so that other passengers can have better conditions if they paid more. And the goal here is to make more money. So the right to make profits should not should not supersede passenger rights. For these reasons, we think that overbooking should be banned. Thank you very much.
Madame.
Thank you, Ms. de Bellefeuille.
For opening remarks, we have Mr. Lawford. Mr. Lawford, the floor is yours. You have 5 minutes.
Thank you very much, Mr. Chair. Honourable members, my name is John Lawford. I'm the Executive Director and General Counsel at the Public Interest Advocacy Centre. And PIAC is a national nonprofit and registered charity, and we provide legal and research services on behalf of consumer interests, and in particular vulnerable consumer interests concerning the provision of important public services. And PIAC has been active in the field of air passenger protection and policy for over 20 years. The air passenger protection regulations are just fine. Removing them or amending them will not ease airport delays or reduce traveler frustration. They are not unfair. They are not overreach vis-a-vis the airlines. The APPRs are hard-won redress and fairness for the flying public. Modern air transportation regulatory schemes throughout the world have such rules, including, as we've heard, the EU and the UK. The APPRs are Canada's answer. There is currently a problem with a backlog of consumer APPR complaints at the Canadian Transportation Agency. There are somewhere between, we estimate, 16,000 and 20,000 that are at least a year old. This backlog is due in part to bad timing. The APPRs were proclaimed, as you heard, just in force ahead of COVID-19. However, it has always been PIAC's position that the APPRs were going to generate a backlog. The CCTA's facilitation, mediation, and adjudication streams within a quasi-judicial formal framework is a ridiculous approach to dealing with high-volume, low-value consumer redress for such routine and unfortunately now chronic issues as flight delays and cancellations. A better model is a dedicated administrative complaints agency with a regulatory overseer for systemic issues. This administrative model is currently in place for telecommunications and broadcasting, which is the CCTS, and for banking and investments, the OBSI. The government should not abandon the APPRs, but should remove them from the formalistic tariff-based adjudication process and transition to a CCTS-like model. We also note that consumer baggage complaints cannot be solved by changing or improving the APPRs because they effectively say nothing about baggage. That's due to the Carriage by Air Act and the Montreal Convention, which stipulate that compensation for lost baggage or delayed baggage must be contained in the airline's own domestic tariffs on baggage. This means that consumer frustration with baggage can only be solved with a directive for the airlines to meet a minimum standard in their tariffs from the Minister or the CTA. PIAC also wishes to underline that the present APPRs are under attack by the airlines. First, by WestJet arguing that all crew shortages are safety cases, and more recently by Air Canada questioning whether crew training is out of their control in appeals to the CTA, from the CTA to the Federal Court of Appeal. We note that in the EU, under their passenger protection regime, staffing shortages generally must be planned for and compensation paid, except in very unusual circumstances, with the implicit message from the regulator to the airlines not to schedule flights for which they cannot manage their labor supply. Second, the major Canadian as well as US and European carriers, along with IATA, are challenging the entire APPRs, at least for international flights, and I was just rereading some of the pleadings, domestic as well, at the Federal Court of Appeal as conflicting with the Montreal and Chicago conventions. This committee can and should, by contrast, express its support for the APPRs despite growing pains and challenges. Consumers need the APPRs as a counterweight to airline power. This committee should recommend future amendments to the APPRs and any other law or treaty to fill any gaps that these airline court challenges reveal. Lastly, we note that the major airlines fired or retired workers during COVID-19. They made their own labor shortage despite taking large CEWS amounts that were intended to keep staff on the payroll. Most airlines also took some or all of the money offered as bailouts, not WestJet, of course, and Air Canada only for consumer refunds, but they were not required to rehire or be ready to restart at the start of this summer. This money only supported their balance sheets in the meantime while COVID requirements faded away. Thank you, and I look forward to your questions.
Thank you very much, Mr. Lawford, for your opening remarks. We will begin our first round of questioning with Mr. Strahl. Mr. Strahl, the floor is yours. You have 6 minutes.
Well, thank you very much to all of the panelists for their presentations, and certainly I know members of Parliament are often very well versed in dealing with airports and airlines, and certainly hear from our constituents who have concerns when things go sideways. I guess the first question I wanted to ask, and perhaps I'll start with Mr. Lukács. You mentioned numerous times, or numerous panelists mentioned the EU as a good model to follow. And another witness indicated that I wrote down the language. It was excellent. Chaos at the airports made us an international laughingstock, and I think we saw that there were a lot of issues with airplanes being held on tarmacs, for instance, because the customs halls were completely full. We heard a lot of attribution that a lot of those delays were due to the flawed $54 million ArriveCAN app. We heard problems with CATSA causing massive security lineups, which had an impact as well. I guess in the EU model that was referenced numerous times, does the EU model take into account all of the agencies, all of the parts of the passenger experience, things that can go wrong with baggage, security, ground crews, airports, all of that? Does the EU model take that into account, and is there any accountability for those agencies that provide services to passengers in addition to the airlines, which are obviously who people pay the money to and therefore expect to get the rebates from? So maybe you could just comment on whether there are additional groups that are impacted by the EU legislation.
Thank you for the question. The EU model deals with the relationship between passengers and the airlines. It is without prejudice to the airline's right then to recover from a third party for its damages. What we need to bear in mind that both under the EU law and also under the Montreal Convention, which is an international treaty, the airline is the passenger's final address for issues. So for example, if the passenger's baggage, after it was checked in, is damaged by security, then the passenger claims the baggage damage from the airline can then go and talk to CATSA or any other security agency to recover those damages. But insofar as the passenger is concerned, it is between the passenger and the airline. We also understand that these are complex systems. The European Union's regime recognizes the notion of an extraordinary circumstance, like a snowstorm, like a volcanic eruption, which relieves the airline from the obligation to pay compensation. However, most situations like ground crew, like fueling aircraft, like ensuring that they have sufficient crewing and that they plan their flights properly is within the airline's control. Airlines had, even in Canada, all the information they needed to estimate the problems that would be happening in the summer. They had all the information they needed to know what would happen and to know that perhaps the CATSA or the airport facilities were imperfect, but they were not able to handle as much traffic as the airlines were selling in terms of tickets. So what happened this past summer was a situation when airlines were overselling the airport's and capacity, the facilities capacity, and they knew it perfectly well. So that would have been in the European situation within the airline's control. It's a whole different situation if, for example, God forbid, you have an air crash and you have to close one of the runways suddenly and it is not known in advance.
Thank you for that. I guess another question I had, the EU perhaps, obviously there are examples of geographical issues as well. I think that when we think of staffing issues, for instance, if you're at the airport that I fly out of often, Vancouver International, you would expect that there might even be, for the bigger airlines, there might be crew on site who could fill in if there was if there'd been a delay that had put the crew over their hours or if someone got sick. Is there any provisions in the APPR, or do you think there should be when there are, for instance, your flight might be in the north or in a remote community? Should there be the ability for airlines to use that as an excuse, the remote nature, the fact that they're in a smaller community, a smaller airport, as opposed to if they're flying out of some of the major centers that you might expect to have more crew available?
Generally, when we are talking about crew shortages, we are talking about situations that the airlines could have known well in advance, like having adequate training for crews probably months in advance. I certainly would support arrangements for special exemptions for airlines that operate north of a certain geographical point in very, very scarcely populated areas in the territories. That, however, should not apply to an airline operating, say, out of Sydney, Nova Scotia, or Halifax, Nova Scotia, or similarly well-populated areas. The assumption of any passenger protection regulation should be that the airline is responsible for the business decision that it makes, and that has to include adequate contingencies.
Thank you very much. Next, we have Mr. Rogers. Mr. Rogers, the floor is yours. You have 6 minutes.
Thank you, Chair, and welcome to all of our witnesses online, of course, and people in the room today. It's all of your testimony provided many examples of individuals and groups that have, been denied refunds and so on, and other issues that you raised. And I think there were a number of factors that unfortunately converged to create the perfect storm of problems for air passengers. And very soon after the government introduced its new passenger rights system in 2019, notably, of course, the pandemic and subsequent shutdowns of most air travel, labor shortages that persisted, and so on. And even after the public health measures were relaxed, we still had major problems. So given that, would you say that on balance we are still better off with a legislative and regulatory framework as opposed to the situation that existed before, when each individual airline set its own system and including compensation amounts? So I'll start with Mr. Lawford and then go to Mr. Charbonneau, and then I'll ask a couple people online there.
So absolutely, we're better off to have the passenger protection regulations than not. I would have started, instead of Professor Gradek in 2019, more like 2003 or whenever it was. Canadian Airlines Air Canada merger was when PX started working on airline issues and the problems of consumers being treated more like baggage than passengers. And we tried to get an airline bill of rights since that time. So we kind of worked on this more for 20 years and finally got them. So we're very fond of them. And as I was trying to make the point, yeah, there were a lot of factors against it. It needs a chance to breathe. And unfortunately, just the administrative turnover is too slow at CTA now to catch up their backlog. But really, it should be kind of like a parking ticket that the airlines are getting, not a big investigation. So I very much support them.
Thank you for the question. It's better to have a framework than none, of course. But it's like imposing speed limits on the highway and no one is there to enforce them. It just lets people drive the speed that they would like. That's really what we're seeing. We could have the best rules if there's no one who's proactively applying them, and that we just wait for complaints, and then that we proceed by managing complaints. We're not any better off.
Thank you. Mr. Gradek and Mr. Lucas?
Yeah, I think that I agree with Mr. Lawford. I think that, the Wild West that we had prior to the APPRs was not really acceptable in terms of the way we handle our passengers. And I think that the APPRs was really, an attempt to draw the line in the sand and said, here's a process that we think, would work. And unfortunately, in my opinion, is that, there are some elements of the language in those APPRs that still leave a lot of discretion, as far as I'm concerned, in terms of the airlines having the ability to, in fact, escape the compensation clauses that are supposedly contained in there. And I think it's incumbent on the committee and on the regulators to basically close some of those issues.
Mr. Lucas?
In my view, the APPR was written by the airlines, for the airlines, and it's essentially a sham. It creates the appearance that there is a passenger protection regulation in Canada. It is serving as a way to provide answers for those legitimate calls to provide a European-style protection regime, but it was designed to fail. We cautioned the government, we cautioned the Canadian Transportation Agency in February 2019 about all the flaws, and we predicted them. We predicted the refund controversy. We predicted the abuse about the safety purposes loophole. We predicted the concerns about denied boarding and so on. We have 52 pages published on our website for now more than 3 years. We knew it was coming. Everybody with a minimal expertise in the area knew that what would happen if those regulations were allowed to go forward in its present form. So what needs to happen now is to actually give Canada a real air passenger protection regulation that provides meaningful protection to passengers.
Ms. Bellafule, I'm not sure, obviously not pronounced that way, it should be, but my apologies. At the moment, it strikes me as one of the main problems that there's not enough disincentive for airlines to go to the CTA, dragging out the process and discouraging travelers from exercising their rights. Would you agree with this assessment? And if so, what should be done to change this incentive structure?
Merci pour la question.
Thank you for the question. Indeed, the process is too intense. Right now, the consumers and the passengers are in a David against Goliath situation. The passengers have to enforce their rights, but they don't have all of the tools at hand to do it. They're fighting against airlines that know how the system works and who have all the information. According to us, we have to reverse the burden of proof. Air carriers should have to justify why they didn't compensate passengers, because we have a very problematic situation here. Very few people will get to the end of the process. For an airline, it's almost advantageous to misinform passengers and deny their responsibility. Let's just say that 10% of passengers contest their decision. It still remains that 90% of them will not receive compensation. This is an insane process, because if you think that only 1 or 2 people on a flight will make a contestation, that would be already great. So there's a balancing of power that needs to be done, and I think the regulations should be reviewed to restore that balance between the powers that be. Thank you, Ms. de Bellefeuille. Next, we have Mr. Barsalou-Duval. You have the floor for 6 minutes. Thank you very much, Mr. Chair. In listening to the various witness testimonies today, it seems that there's an agreement around the table. The current process for processing complaints is not functional. Hearing what you've said, it seems that the system is broken. And in the end, the result is that passengers are discouraged and airlines are encouraged to mistreat consumers and not respect their rights. I did hear some solutions that were proposed, and here there are some differences, and that's what I'd like to hear your opinion about. Ms. de Bellefeuille was talking about having an approach that would reverse the burden of proof and that airlines should have to explain why they did not compensate their passengers. So anytime there's a canceled flight, they should automatically refund passengers, and if they don't, then they have to justify it. Do you think that this approach, I'm asking this to all the other witnesses, would be a good one? Mr. Charbonneau. Of course, the burden of proof should belong to the airline, but again, they can try and pull out any kind of evidence, and a passenger wouldn't know whether or not to believe them, and they won't know what to do with it. So we still need someone who will decide whether or not the facts that were presented by the airline are valid. So maybe this would be the CTA or someone else that would have deciding power, and they would have to decide quickly at the first stage if this is valid. We want to avoid delays, and we want to reduce complexity. We also don't want travelers to have to do all of this on their own. That's what they're doing now. And airlines are now forcing passengers to do this kind of work. Just like Madame Bellefeuille was mentioning, passengers are not equipped to confront a multinational with unlimited resources.
Monsieur Lukács.
Mr. Lukács?
We need to fix more than just the burden of proof. It should start with clear definitions that mirror the European Union's definition of denied boarding and cancellation. And then we need to move on to a presumption of liability for denied boarding, delay, and cancellation on the carrier's part, like in the Montreal Convention, that the carrier then has to rebut. The carrier then has to show the extraordinary circumstances because of which they should not be paying compensation. We also recommend the removal of the safety reasons loophole, which does not exist in the European Union's regime, and it creates a lot of room for abuse. So we agree with each one of the solutions, but we believe that we need all of them together to fix the system. Ultimately, one should not be requiring 1,000 pages of documents to decide the fate of a $400 compensation claim.
On terminerait peut-être avec Monsieur Lawford, si vous avez des...
Mr. Lawford, do you have comments on this? Yes. I would like to say that in telecommunications field, we have a similar problem. Companies have great means, and they're facing consumers who don't. So we have experts that are looking into files and ask companies to respond within a month, to respond to consumer complaints within a month. They do a bit of mediation as they are experts, and it helps a lot. 80 to 90% of complaints are resolved within a month or 6 weeks. So it's much more efficient. Thank you. Ms. de Bellefeuille, earlier, through your speech and in the questions, you underscored the fact that often there's a minority of consumers that will actually go through the process to get their compensation, the ones who will complain. So carriers come out on top after having bad practices. For example, what if there was a rule that said that as soon as one passenger that receives compensation or that a case was proved about a given flight, shouldn't compensation be applied universally, or should the information be shared with the other passenger so that it's fair for everyone? Indeed, this is one option that would be very interesting. Currently, the powers of the CTA apply only to the person who complains, but the complainant is not the only one who is inconvenienced. So there should be a way to bring everyone together to benefit from the results of one person who took up the fight. But then sometimes compensation is done on a case-by-case basis for certain travelers, but I think that that's an interesting solution. Mr. Charbonneau, what do you think? The microphone's not on. Sometimes a situation can apply to many flights. For example, the lack of crew or crew that was working too long, and then flights were canceled for security reasons. There were decisions that were rendered, one against Air Canada and WestJet. And yes, these decisions should be applied to everyone who received misinformation at the outset. There are tens of thousands of travelers that received misinformation, and they didn't get the correct information, and therefore their rights are also violated at the end. Thank you very much, Mr. Barsalou-Duval. Mr. Bacharach.
Thank you, Mr. Chair, and thank you to all of our witnesses for being here today. I think what we've heard so far at this meeting is a pretty stunning indictment of the air passenger protection regulations and how they've been enforced during a time when air passengers across the country have gone through some pretty extreme circumstances and put in extremely inconvenient situations. And of course, this study that our committee has undertaken is coming at a time when there's over 20,000 complaints before the CTA, and right before the Christmas travel season, when I think we risk seeing that number jump even higher. So I have a whole bunch of questions. I want to start with Mr. Lukács. Welcome back to the committee, Mr. Lukács. And I want to start by asking you if you could elaborate on the specific regulatory and legislative changes that you believe this committee should recommend as a way of strengthening Canada's air passenger rights system.
Thank you for the question. The first change is incorporating in the Canada Transportation Act a clear definition of denial of boarding and cancellation, which mirrors the European Union's definition. We often hear, for example, that a flight was not canceled, it was just a schedule change, and the airline refuses to pay compensation on that basis. The next change is the removal of the safety reasons loophole. It would involve removing subparagraph 86.11(1)(b) Roman 2 and adding a language to clarify that delay, cancellation, or denial of boarding for safety purposes is deemed to be within the carrier's control. The third change that should be, again, in the Canada Transportation Act is a clear presumption of liability for denied boarding, delay, and cancellation, that it is presumed to be within the carrier's control, like in the Montreal Convention, and the burden of proof is on the carrier to rebut with evidence that presumption.
Mr. Lukács, we heard earlier from Mr. Charbonneau that the DOT in the United States has already issued $7 million worth of fines to air carriers who, and I believe the translation was, who slow-walked the refunds that they were supposed to provide to passengers. Now, the APPR in Canada also has a provision that allows the CTA to levy fines against the carriers for contravention of the regulations. Has the CTA used this tool, and if so, how effectively?
The Canada Transportation Act allows the CTA to issue fines up to $25,000 per passenger per incident for violations of the APPR. With respect to the main provisions of the APPR relating to compensation of passengers, I'm aware of only one fine very recently issued against WestJet for $11,000 for 55 violations, and that was for $200 per violation. And that's for violations of provisions where the amount at stake, compensation owed to passengers, is between $400 and $1,000. So it was actually cheaper for the airline to pay the fine than to compensate the passengers. With respect to those issues, our recommendation would be to have mandatory minimum penalties for airlines that break the regulations and mandatory enforcement provisions, as well as increasing the limitation period from 12 months to 36 months or longer for the CTA to issue penalties to airlines.
And then if I may, I'll turn to Mr. Charbonneau. The APPR requires that airlines communicate to passengers about the existence of the APPR so that they can pursue claims. Like many people in this room, I fly a lot and had a lot of flights canceled and delayed over the past year. I think I can count on one finger the number of times that I was handed any information about the air passenger protection rights. At one point, I asked a boarding room full of people whose flight had been canceled if anyone was aware of these regulations in Canada, and not a single person put up their hand, much to the embarrassment of my teenage daughters. Now, my question is, you mentioned that only 2% of passengers actually pursue claims. I'm wondering if that is because the process is not well publicized, or is it because the process is so complex that most average air passengers aren't going to go through the process and find their receipts and go through a 30-day process of appealing to the carrier and then appealing to the CTA? Which of those two, or how much of each, is the problem here?
It's a mix of the two situations. There's a lack of awareness of their of their rights and air carrier obligations, but there's also a lot of misinformation that's given out at the outset, or even a lack of information. Here's an example that I went through myself. A few weeks ago, I went to Halifax for the weekend. I had an early morning flight, and then our return flight wasn't appearing on the screen, and then we could see that the counter was only opening at 3:30 in the afternoon. It was 8 in the morning. All the passengers were there. We didn't know if the flight was delayed or canceled, if there was going to be another flight. No one was there. I was talking to the 90 people that were waiting to tell them what their rights were, what the carrier's obligations were, and all of those people had to fend for themselves. Often, when there is communication, we're told that these are exceptional circumstances. There's nothing that we can do. There's no compensation. And when I dug further, I was told that there were security reasons, and I never got to the bottom of it. I never understood what the real reason was. Thank you, Mr. Charbonneau.
Next, we have Mr. Muse. Mr. Muse, the floor is yours. You have 5 minutes.
Thank you, Mr. Chair, and thank you to the witnesses. I know some are repeat witnesses to the Transport Committee, so thank you for your investment and time here. Mr. Lawford, you I think painted a picture of chronic issues and flight delays is what you talked about, and you talked as well about maybe looking back a lot further in the time continuum to 2003 to now. And so I'm wondering, in your view, and maybe you can elaborate a bit about this, what are the factors that are causing these delays, we've seen these spikes in delays and these frustrations that consumers are facing that are remedied by the APPR, and what are factors outside of that? I mean, where's the division, and how has that progressed over time?
I don't think that the APPRs themselves have any large effect on cancellations or delays. I think when we went into this, after Mr. Emerson did his report, when we were setting up the regulations, that we thought that, if airlines had a lot of fines to pay for these cancellations and delays, they'll change their habits. Well, it doesn't work that way. It actually looks like when they get a number of claims, they continue to cancel flights because the economics are so much larger for choosing a different aircraft or changing the schedule or not having staff, and that those costs really, I think, pale compared to the consumer's compensation. So really the scheme, I've come to think, is more about compensating consumers for their inconvenience because the system isn't going to work. And we have other problems, as I think you heard in the previous committee meetings, about the way airports work and the way security works and all of these international flight and competition issues. So you can still fly. See, this is the whole thing about this entire thing that really gets under my skin, is airlines can still fly. They can fly late, they can cancel flights, they just have to pay. And what we're missing here is this sort of automatic, for a flight of if 100 people on a 200 flight plane make a claim, well, too bad. Pay for 100 cancellations or 100 delays, and that's the cost of stranding people if you're going to operate like this. And that might give them an incentive to change it in future, but at least those people will get something for having been, crushed under the wheel, so to speak.
Is that always the fault of the airline? I mean, we know, and you referenced the number of issues we had this year in particular, and the headline that we all were horrified by this past summer, that Toronto Pearson was the worst airport in the world.
Yeah.
And so I mean, what are those other issues, and how are they being addressed?
I'm not downplaying the complexity or difficulty of running an airline, especially in the present circumstances. What I'm saying is, if you're going to be in the airline business, it's an essential service to get people from A to B. So if you strand them, you have to pay for it. That's what we've come up with, because it's so important to people and it's so essential. It's just going to have to be factored into your costs. And yet I see Air Canada and WestJet going to the mat, and IATA trying to take out these regulations, and it's just very disturbing.
So in my previous life, prior to politics, I did a lot of business travel in the United States, and I know the EU was referenced as a model that we could look to. I'm wondering if any of the witnesses would like to comment about whether the U.S. because in all my time, I found very few delays, very few issues. In fact, often if I booked too tight of a connection, I was running between gates. And so, is there something we can learn, or is there something instructive from the U.S. model, not just the EU? And are they better off or worse off than Canada in this regard? So I don't know who wants to. Maybe Mr. Gredick, given your years of experience in the industry, could start off.
Yeah, I think that one of the things that we see happening in the Canadian aviation marketplace is, what I would say is a gradual reduction in the integrity of airline managers basically looking towards making passengers enjoy their trip. And what we see happening is that you see more and more decisions being made by the airlines to basically look at minimizing the impact on profitability. And that's where, we have the traditional fight going on between customer service, or do we basically deal with profitability? And I think, the pendulum has swung at this point in time towards profitability because of the fact that the airlines have been short of profits for the last 24 months and are trying to catch up. Now, will we in fact come back to a pendulum point where customer service will in fact take precedence? Probably. Not sure how long it's going to take to get there, but it'll happen. And it'll be a question of carriers all of a sudden, deciding that customer service is worth more, and we'll try to get some competitive advantage by providing a level of service. But I think the EU model, I think they've had a lot of experience. They've had close to 20 years worth of this regulation being in place, and it's interesting. They have kind of privatized the whole process of having people identify themselves as being subject to compensation. If you go onto a UK or EU website...
Thank you very much, Mr. Gredick. I'm sorry, I'm going to have to cut you off there. I tried to give it a little bit of leeway, but unfortunately we're out of time. Next, we have Mr. Chahal. Mr. Chahal, the floor is yours. You have 5 minutes.
Thank you, Chair, and thank you to all the witnesses today for your testimony. We've talked a lot about the impact on air travelers and their experiences, and particularly a lot of these challenges have come because of the challenges we've seen during the pandemic. And I'll start with you, Mr. Lawford. What was the experience of Canadian air travels compared to travelers in other countries? Now, if we look at the U.S., as mentioned by my colleague, or in Europe, what was the experience, if you could compare?
Each airline market recovered at a different rate. I think that the Canadian experience was a rush to try to service, especially this last summer season, a little too quickly. The U.S. Market recovered in a more staged manner. I'm not sure whether they had better labor management. And Europe, I have to say I haven't studied in as much detail as maybe Mr. Gredick or Mr. Charbonneau, so perhaps they could speak to that. But Canada did have kind of a turn it right off, turn it right back on full blast kind of approach, and especially after taking the bailouts, that it was surprising that there was so much labor shortage in Canada, and that was really the source of most of our problems. But as we heard in the last study, there was problems with other aspects of the government.
Was consumer protection in Canada adequate compared to the U.S. or Europe, in your opinion?
My bottom line here today is that the passenger protection regulations are fine. We worked on them. They've got the substantive stuff we need to resolve most Canadians' complaints. The trouble is that the system that they've been shoved into is an old-fashioned tariff system that just isn't built to process a lot of these claims. And without the perfect storm, as Mr. Rogers noted, the backlogs just become too big, and so it looks bad.
Mr. Gredick, could you comment on the same question?
Yeah, I think that what you see happen in North America or in Canada was really a situation where the airlines basically did not take the effort, did not take the initiative to maintain staffing levels the way the European or the American level carriers have done. Air Canada, dropped somewhere close to 20,000 employees, WestJet 15,000 employees. and they were slow bringing people back. And meanwhile, they decided to fly a fairly aggressive flight schedule. So it really was a situation where the Canadian Airlines, basically took the initiative to fly, to publish a flight schedule, and without having due regard to the resource levels required for them to support those flight schedules.
Experience of air travelers was better in Europe or the US compared to Canada, and the strengths of consumer protection in comparison?
Well, I think the European carriers, and the European airports basically had some level of disruption. You look at Schiphol Airport, you look at London Heathrow, look at Frankfurt Airport. They all had situations, albeit not as bad as we had them in Canada. So there was some disruptions due to shorter staff shortages, and I think that that there was really much more a conscientious view from the carriers about the need to have resources to basically start up again, and that was not the case in Canada.
EU had maybe a better system, or I guess if you could compare and contrast the strengths of their system when it comes to protecting passengers or travelers, and what recommendations you would bring forward for our study here.
I think that the number of people this afternoon, Gabor has basically made the point about looking at trying to absorb as many of the EU regulation changes as we could into Canadians. But the Europeans have basically said that situations associated with delays really are payable by compensation, and the only time that you basically have an exemption is under extraordinary circumstances. In those extraordinary circumstances, no compensation is due. So staffing shortages, maintenance requirements on airplanes in Europe, the airlines are basically liable for payment of compensation. When you have a volcano, or you have a political disruption, you have, runway incursions, you have major events for which the airline has had not a chance to look at reasonable planning around that event, then you have compensation. Otherwise, all's fair.
Thank you very much, Mr. Chahal, and thank you very much, Mr. Graddick. Next, prochainement, nous avons Mr. Barcelou-Duval.
Next is Mr. Barcelou-Duval. You have 2 minutes and a half. You have the floor. Thank you, Mr. Chair. I'd like to talk about the complexity of the complaints processing system with the CTA and also the complication of the regulations. Here we're saying there are all sorts of situations that can lead to all sorts of resolutions. And it turns out to be a puzzle. Whose responsibility is it under these circumstances or another circumstance? And we're going to create backlogs in an administrative tribunal. I know that amounts can go from $500, $1,000, $2,000, and then we find that the costs of creating all this documentation, of hiring lawyers to go to court, public servants to deal with this. And, before the pandemic, I had tabled C-2049 that aimed to make things more simple. It said that if a flight is canceled, there's a refund. It's simple. Cancellation equals refund. If I order a pizza and I don't get a pizza, I get refunded. If there's a snowstorm or if the delivery driver didn't have his winter tires or if there was traffic, he still has to bring me my pizza. He doesn't bring it to me 3 weeks later. He brings it to me that day. And if he can't, then I'm refunded. Wouldn't it be simpler to just do that instead of trying to figure out all sorts of rules and hire a bunch of public service servants to come up with a system that doesn't work? Why don't we just go back to my original proposal in C-2049. I'd love to hear your opinion, Ms. de Bellefeuille, to start. Indeed, what you're proposing is, this is really the basis of contract law. The base here is that we have a company that is offering a service. Consumers pay for the service. The company doesn't provide the service, and therefore the rules should be that the consumer gets reimbursed. Why would it be different for an airline just because it's an airline? There's something here that doesn't make sense. In the same way, if you ordered a pizza, a pepperoni pizza, and you receive a pizza that doesn't have pepperoni, there's still a problem. It's still not what you ordered. So if you bought a flight on a Saturday and they tell you that you're going to leave only on the Monday, but it's okay because it's still 48 hours later, that also doesn't make sense. Inaudible, the microphone wasn't on. Maybe Mr. Lukács and then Mr. Charbonneau. You have minus 10 seconds. So we'll let Mr. Lukács answer, and then we'll stop there.
Providing a refund in any event, regardless of the cause for the cancellation, is of course makes perfect sense. That's what the law in the European Union and the US is. However, if the airline cancels a flight for reasons that are not extraordinary, they also have to compensate passengers for their time, their inconvenience, because after all, that is also a cost to economy. When 200 people don't reach their destination on time, that has a productivity value that has to be paid by the airline.
Thank you very much, Mr. Lukács, and merci beaucoup, Mr. Barcelou-Duval.
Thank you, Mr. Barcelou-Duval.
Mr. Bachrach, the floor is yours. You have 2.5 minutes.
Thank you, Mr. Chair. We heard in previous testimony about the challenge that's presented when a whole flight of people is inconvenienced by a delay or a cancellation, yet only a small percentage of those passengers have the tenacity to go through a very bureaucratic and lengthy process to pursue compensation. Now, every single passenger on that flight had the same experience, and yet only a tiny percentage are going to possibly get compensation. This seems like a situation that heavily favors the airline, because even if they have to pay out, it's only to a fraction of the passengers affected. Now, I understand that the legislation provides the CTA with the power to actually make determinations on a flight-by-flight basis as opposed to a passenger-by-passenger basis. I wonder if Mr. Lukács, if you could talk about this power that the CTA has and whether it uses it effectively.
Thank you for the question. So under Section 67.4 of the Canada Transportation Act and Section 113.1 subsection 3 of the Air Transportation Regulations, the Canadian Transportation Agency can make determinations that are applicable to all passengers or some passengers on the same flights as the complainant, if there's already a complaint before the agency. I have not seen any decision where this actually has been done.
Also ask Mr. Charbonneau if he's heard about this provision being utilized by the CTA.
Of personal memory, I've never seen such a thing being applied, but we have to know that there are 3 steps at the CTA. So facilitation doesn't come with a formal decision. It's just for people who get all the way to the formal process. It's a very low number of people who make a complaint that get that far. Most people will be sent through facilitation, and then there's no binding decision, and it won't be applied to everyone. So that's part of the process that's not working.
If I have a couple seconds left, Mr.
You have 30 seconds left,
Perfect.
Mr. Bachrach.
I'm a little bit confused because the EU had regulations first. The EU's regulations protect passengers better by almost any metric or indicator that you would go with. Why is Canada so poor at protecting consumers compared to other jurisdictions like the EU and the US? Like, why didn't we just simply copy the legislation that was proven to be effective? Mr. Charbonneau, do you have thoughts on why this is the case?
A lot of this comes from the role that organizations play, sideline players, so to speak. For example, I was talking about fines that were imposed by the Department of Transportation in the United States. That's $7 million in fines because compensation took too long to be paid out. If you think about travel credits, the Department of Transportation asked for refunds automatically. In Europe, it was the same thing. In Canada, it took months to accept this, and it was dealt with piecemeal by airlines. So there's a lack of proactivity from the CTA, and it doesn't put enough penalties on the airlines that are not following the rules. Thank you, Mr. Charbonneau.
Next, we have Dr. Lewis. Dr. Lewis, the floor is yours. You have 5 minutes.
Thank you, Mr. Chair. And I would like to also thank the witnesses for their testimony here today. It's been very, very informative, and it sheds some light on the information that we've already have about the unprecedented disruptions to the flights and delays and cancellations over the past 2 years. So my first question is for Mr. Lawford. I would like to know if your numbers that you've stated between 16 and 20,000 if those numbers for the labor shortages, you said that actually you said that there were 16 to 20,000 backlog of processed responses, and you said that it was within the last year. I was wondering if that number also includes those that are 2 years old, or do you have another number or is that just for 1 year?
I was going on the Canadian Transportation Agency annual reports and other reports to come up with a number 16 to 20,000 that were at least a year old. At least, so they were in, as was pointed out by one of the other members, in that more adjudicative kind of stream at Canadian Transportation Agency, meaning they're looking at them in detail. So that's the number I was referring to, if that helps.
Okay, so there could be more than 20,000 backlog.
Yeah,
okay.
There's some newer ones too, always more.
And are you aware of what numbers are attributed to labor shortages? Do they wouldn't state that was the cause of a delay, so you wouldn't know what those numbers are?
No, I wouldn't be able to give you a firm figure on that.
Okay, my next question is for Madame Debefieux. I'm not sure if I pronounced your name correctly, and I apologize if I did not. You spoke in great detail about conflict and the conflict that's inherent in the airlines actually providing responses as to why the delay occurred. And it sounds to me like you're advocating somewhat of a new system where there would be minimum standards. And in that system, could you foresee something by which there is, say, for example, a scale of compensation where there would be minimum compensation, and the airline would have to stipulate whether or not it was due to insufficient staffing or due to a safety issue, and those issues would not absolve the airline of their responsibility to compensate?
En fait, je sais que mon nom est très difficile à prononcer.
I know my name is so difficult to pronounce, and so I'm not offended, I promise. On our side, what we think is that it's all in the writing of the regulation. Currently, it leaves too much space for interpretation by the airline. So now, when an incident occurs, the airline will place the incident within a category, our responsibility, not our responsibility, or a security issue. And that's where the problem is. It's not really about the level of compensation that's listed in the regulation. What we're seeing is that airlines interpret the regulations very broadly and in their own favor in such a way that they don't have to compensate passengers. And this is the conflict of interest that's built into the APPR through its writing.
Ability to interpret it broadly if it was just a fixed scale of the incident occurred, therefore it leads to a compensation, somewhat of a reverse onus. That would take the power outside of the hands of the airline and put it more into the hands of the consumer. Would you not support a system of that nature?
En fait, c'est pas.
It's not about the amount of compensation. It's really of the reason for which there should be compensation. Here is where interpretation comes in. Airlines tend to interpret the regulation in such a way that it favors them. So it's more about the application of the APPR. The idea is not to review the regulation, but to review how the regulation is applied. Right now, the consumers have to make requests, and then the consumer also has to prove that the airline misinterpreted the APPR, and they don't have all of the information to start with. So it's really about a lack of information, and of course, the fact that airlines have an interest in saying that it wasn't their fault. Thank you, Ms. de Bellefeuille.
We have Mr. Badaway. Mr. Badaway, the floor is yours. You have 5 minutes.
Thank you. Thank you, Mr. Chairman. I think we recognize in this conversation, over and above the lack of consideration by airlines for the customers, the need to look at the mandate by the CTA. And I do want to give the opportunity, because we all recognize as well that within these committee meetings, your testimony is going to form the basis of the report that goes to the minister, and then therefore the response from the minister on that report with respect to future recommendations. So what I'm really interested in is on those recommendations to fix, or quite frankly, update the problems at the CTA. And frankly, I want to focus on the business of good government, not, as we may have seen today in today's meeting, the business of good politics. This issue simply does not have time or patience to allow politics to rear its ugly head. So with that, the governing, the policy, the legislation is established by Parliament. The administering, implementing that policy, that legislation, is the responsibility of the CTA. What we're hearing today is a narrative to actually fix the problems that are happening within the CTA. I have my opinions. I have my problems with the CTA in my own writing, so I get it. I understand exactly what you're all talking about. So with that, I'm going to open up the floor, and I'm going to start off with Mr. Lawford. Mr. Charbonneau, you're going to follow. On recommendations to update legislation with respect to the CTA mandate, to update legislation that would actually be the responsibility of Parliament on the mandate of the CTA mandate, or the CTA mandate, ensuring that the process is user-friendly. And I'll say, and other. My second question is going to be, with respect to that, do you feel the Minister of Transport should have a role with respect to ensuring the CTA mandate is adhered to, over and above only establishing or updating that legislation, versus forcing individuals to have to pursue accountability through the courts? Mr. Lawford, we'll start with you.
The first question is easier to answer. One way I would suggest that doesn't involve a lot of backing and forthing and changing of the act that creates CTA is to do, again, what the CRTC did, which was there was a directive from the government that said, can you please make a consumer complaints agency? And we're waiting. And they gave them 1 year to do a report and, in effect, to set up that system. And what came out was the Commission for Complaints for Telecom Services that now does it at semi-arm's length, but is overseen, especially for systemic issues, by the CRTC. So they didn't have to change legislation for CRTC. They just asked them to set up this semi-arm's length. It's paid for mostly by the industry, and yet it's administered through the CRTC, through this new body, the CCTS. That would be one way to get around this quickly without having to amend a lot of legislation. Your second question, I guess I didn't quite understand, so I apologize. Maybe you want to circle back to me to not waste time.
For the first question, I think it needs to be more than friendly. It has to be fast, and they need to have tooth. So the first line should be able to ask for proof. They should be able to understand those proof and to make a decision that will be executory. For the second part, je pense que l'Office des Transports.
I think the CTA needs to be more proactive. It shouldn't wait for there to be complaints before acting. It should be watching airlines to make sure proactively that they're following the rules.
Thank you. I'm going to move on now to Ms. Di Bellafio. Same question. Madam Prompter.
Moi, je pense que
I think the question was for you, Ms. de Bellefeuille. I'm so sorry, I hadn't heard. I have a very similar opinion as what was said earlier. I think that the CTA needs to have enough power to intercede. I think we should extend some of their powers. For example, in situations where there are large-scale disruptions, they could be more proactive there. That would be very interesting. On the methodology to avoid delays inherent in the legislative process, maybe there is many ways we could do this, but maybe we could clean up the regulations. Maybe that would make things easier, and then maybe we could look into the act.
Thank you very much, Mr. Badaway. Merci beaucoup, Madame.
Thank you, Madame de Bellefeuille.
Mr. Lewis, the floor is yours. You have 5 minutes.
Thank you, Mr. Chair. Thank you to all the witnesses. Just really quickly, I guess it's my place. I get to vent a little bit, Mr. Chair, finally. So 2 weeks ago, I jump on a plane in Ottawa. I fly to Pearson. I get off said plane, and my flight is canceled. So I'm giving a Crown Plaza certificate to go stay in a hotel and two $10 vouchers, which are great because that lasts a long time in the airport for sure. And I've got a 9:40 appointment for the next morning to get on a plane to get to Windsor, which is canceled. And then I have a 4 p.m. to get to Windsor, which is canceled. And then I have a 7 p.m., which is canceled. And all that to say, at 9:40 Sunday, that one went to Windsor. So what did I do? Having some kind of a crystal ball, I decided to jump in an Uber on Friday night so I could get home to my meetings. So that's Chris's frustration. But what's more important than Chris's frustration is the frustration of the business owners that flew in this spring. I used to sit on the International Trade Committee, that flew into Windsor this spring and sat on the tarmac for hours they were there to finalize major $1 million deal for automotive, and they couldn't get a CATSA member or a CBSA officer to clear them off of the tarmac in Windsor because one of their apps, Mr. Chair, didn't work to no fault of them, so they got back in said plane and flew back to the United States for Canada to forever lose the business. So, Mr. Lawford, through you, Mr. Chair, Mr. Lawford, so, sir, you said labor shortages played a major role, and I heard you say that, and you went on to say, however, there were problems with other aspects of the government. What other aspects of the government are you talking about, sir?
I was referring to some troubles around ArriveCan and also to do with the staffing of border control CBSA staffing and on the front end coming in with the scanning. But the airports are better to answer this than me, but it was certainly not just airline staffing issues. It was unfortunate, but it had a knock-on effect for a number of other systems.
Thank you, Mr. Lawford. Through you, Mr. Chair, to Mr. Graddick, do you have any comments on that, sir?
Well, I think it's something that we've all talked about, repeatedly over the last 4 or 5 months when we look at, the messes at Pearson and the messes at Trudeau about staffing levels. So it's nothing new. I think that the question really is, what started this whole process and who's to be held accountable for all of these, problems. And the issue that you talked about at Windsor, it's not within the airline's control. It is really within within CBSA, within the border patrols, basically look at staffing and having the right equipment and the right processes in place. So while it's not as headline grabbing as what happened at Pearson or Trudeau, it was a problem and it continues to be a problem in terms of staffing levels at various airports across the country. And we're still going through a process of trying to find people to staff those roles and to make sure they have the right equipment. So it's not going to go away anytime soon, unfortunately. We're still going to be caught in a situation where we're still going to be short of people.
Thank you very much. I'm sure my time is almost up, is it not? You have 1 minute. I have 1 minute left. Okay, excellent. Well, then, I was just going to comment to say that obviously labor shortage across our country in every sector, right? We're bleeding, we're hemorrhaging, quite frankly. And there's nothing more important than labor. We can have the greatest widget in the world, and we won't be able to sell it or build it if we don't have the proper labor. So, Mr. Chair, with that, I want to say thanks again to the witnesses. I appreciate that. I know this is not a flip of a magic wand, but it's something that we need to seriously get to the bottom of for Canadians, but not only in our own country, but traveling abroad. So thank you, witnesses. Thank you, Chair.
Well, thank you very much, Mr. Lewis, and I'll be sure to remember the fact that you left 40 seconds on the table when the holidays come around. Mr. Iacono, la parole est à vous.
Mr. Iacono, you have the floor for 5 minutes.
And I'll address my first question. I would like to thank the witnesses for being present today. My first question would be for Mr. Lawford. How much data do we have about passenger experiences? Do we know how many complaints are registered? How many are successfully resolved? How much compensation is paid out? And is this broken down by airline?
On the last, I don't know if it's broken down by airline. I do know that the total compensation figure is given by CTA, the total number of complaints, and there's not a lot of granularity. I compare it to the CCTS, again, back to telecommunications, where it is broken down by telecommunications carrier, type of complaint, and period that we're talking about, and the resolution rate. So those kinds of details are not, to my knowledge, in the CTA reports, which are a little more high level. So some more granularity would assist everyone in this project.
Do you think it'd be possible to have access to those data just to give us a better idea?
I believe so.
Well, thanks. And also, in general, what would you recommend in terms of data collection and sharing?
Again, I'm back to that telecom regulator that is very open, provides open access to the spreadsheets that the frontline staff use, with a few fields blocked for sensitivity, but otherwise almost exactly what the investigators see and the management at the CCTS. That could be made available publicly because it's been done in another industry, and that would help researchers as well as consumer advocates and even airlines see where the problems and pain points were.
Thank you. Madame de Bellefeuille.
Ms. de Bellefeuille and Mr. Charbonneau, welcome. Some witnesses have already suggested that one of the main problems in the process is that it has a court model, which creates backlogs. There are too many decisions that have to be made by a small number of adjudicators. Do you agree with this? And if yes, how can we correct this situation?
Merci pour la question.
Thank you for the question. Indeed, the harder the process is, and if it is a court model, it's much more difficult for passengers and consumers to have their rights respected. So if there could be a more streamlined first-line process, it would be better. If we gave the CTA the information from the get-go, they could process complaints, and we would have a system that operates more quickly. But we still need to have enough staff within the CTA to manage this volume of complaints. I don't know if that's currently possible, but it would make things much more easy. Monsieur Charbonneau. Inaudible, the microphone is off. The decision needs to be binding regardless of the structure. So the people who make the decisions have to make those decisions binding. I think we do have to have a simplified process. I think they did so in Denmark. It's much faster. And also to bring in cases together allows us to process them together. For example, people who were in the same flights under the same circumstances, then we could deal with hundreds of complaints at a time. The system has to be simple and fast. The fact that now it takes a year or two, people end up getting discouraged. They don't see their money within a year or two. They don't understand the relevance of continuing to fight when they can't. They just get repeated what the airline says, and the facts are not even verified. Thank you to both of you. So who pays for these compensations and the fines? This doesn't come out of the salaries of the CEOs, does it? So this is actually paid for by all passengers through the increased cost of flying. How can we limit this kind of unwanted consequence?
Je pense qu'effectivement,
Indeed, nothing is ever free in life, and there is a cost associated to it. But if we look at what's happening in Europe, I wouldn't say that the prices of flights in Europe are higher, and meanwhile, compensation is more automatic. So depending on how you manage things, maybe some CEOs are a little too hungry, and I don't want to emit an opinion about that, but yes, it will have an impact on the cost of tickets. But currently, the problem is that the impact is felt by passengers through the violation of their rights, and I think that's unacceptable. What do you think of the financial support that the federal government negotiated with airlines throughout the pandemic? This including the obligation to reimburse passengers. I think that, unfortunately, it was too little too late. It took almost a year to put that system in place. And the problem here is that compensation periods were very short, sometimes only a few weeks. In the best case scenario, it was 4 months. And some people didn't even realize that they had to produce a new request. So some had been arguing with their airline for over a year, and then they found out that they had to produce a new request, and that made no sense for those people. So unfortunately, we needed to act sooner. Thank you. Thank you, Mr. Iacono and Ms. de Bellefeuille. Next, we have Mr. Barcelo-Duval. You have 2 minutes and a half. You have the floor. Thank you, Mr. Chair. My question is for Mr. Charbonneau. I'd like to pick up where I left off earlier, asking about why we shouldn't just make things simple. If a flight is canceled, there should be a refund. I was proposing it in C-2049, and I know that this doesn't tackle every issue, but I think it would eliminate a huge chunk of them. Mr. Charbonneau, I'd like to hear what you have to say about that. I agree that refunds are required. However, when we automate things, we have to make sure that it's actually done. Right now, the only thing that's automatic with the APPR is the overbooking compensation. And even there, we see that it's not always respected. So we have to make sure if people are following the rules. Also, we have to make sure that if there are refunds for passengers, but let's not forget that that passenger is still turned around. They have to buy a new flight. They have to go back home. They have to buy meals. It always ends up being hundreds of dollars more. So their flights are canceled. They have to buy more. Maybe their tickets is twice as much to buy the same flight, and they're stuck at the last minute at the airport, and maybe there won't even be a flight. So we have to take into consideration the prejudice against this passenger whose flight is canceled as well. Yes, those consequences are important too. You talked about overbooking. Ms. de Bellefeuille said earlier that this practice should be banned. What do you think of this? Well, I'm not the person to speak about whether or not this should be allowed, but if I speak for consumers, I would say that definitely no. But there's also a commercial aspect. Some people don't show up for their flights, and that's why they do overbook flights. That's why the government allows overbooking. However, I will say that we have to plan use case scenarios. This is what's happening in the United States. There was a passenger that was forced out of a United flight, and these people they'll offer up to $10,000 to people who could volunteer to get off a flight instead of forcing people to get off a flight. I don't know. Unfortunately, you have no more time.
Mr. Bachrach, the floor is yours. You have 2.5 minutes.
Thank you, Mr. Chair. I'm intrigued by this idea around banning overbooking. That hasn't been part of the broader conversation around air passenger rights, which has been focused on delays and cancellations. To Ms. de Bellefeuille, I wonder if you could share with the committee how you feel that could be achieved. Is it a legislative change? Is it a regulatory change? Where would that ban on overbooking be instituted?
Au niveau de l'application, c'est un peu...
In terms of application, it would be a little bit difficult. I didn't see exactly how we could do that, but perhaps it could be through the APPR or through the Act. I know that this kind of incident could lead to a higher price of tickets. Perhaps we could have focus more on standby tickets, and that way consumers know that they could possibly be bumped. Then there are fewer bad surprises, and that's not what's happening. People buy a ticket, and then they find themselves caught off guard at the last minute, and that's what doesn't make sense.
You've pointed to challenges with the underlying legislation that made the APPR possible. To what extent was the APPR built on a faulty foundation legislatively?
En fait, ce qui se passe, c'est que...
What's happening is that, in our opinion, the APPR is not the only thing that imposes obligations on the air carriers. There are provincial laws, and what we saw during the pandemic is that people were focusing only on the restrictive interpretation of the APPR so that airlines wouldn't have to reimburse their customers. However, there are other acts like the Consumer Protection Act in Quebec that could apply. And I think that that was part of the problem, is that we limited ourselves in our interpretation of the acts and the federal regulation.
By the comparison with Europe and the way that other jurisdictions are protecting air passengers, are there any ways that you can think of that Canada outperforms the EU and the US when it comes to consumer protections for air passengers?
Je suis pas familière.
I'm not very familiar with the EU regulations, but what I've heard so far, it seems that we're lagging behind on the best practices that exist in the EU. Thank you, Madame de Bellefeuille, once again.
Backrack. Next, we have Mr. Strahl. Mr. Strahl, the floor is yours. You have 5 minutes.
Thank you very much, Mr. Chair. My question is for Mr. Lawford. You mentioned earlier about how this compensation is not particularly designed to change the behavior of airlines. It's designed to compensate travelers. So I guess I was interested in the minimum levels of compensation between large airlines and small airlines. Small airlines are defined, or large airlines are airlines that have transported a worldwide total of 2 million passengers or more during each of the 2 preceding calendar years. So I guess my question is, if it's about compensating passengers, why are there 2 different levels of compensation based on the whether an airline is considered large or whether it is small?
That was a method that the Department of Transportation used to try to balance out a lot of problems for the smaller airlines and a lot of complaints when this was being brought forward in negotiations over the regulations. For example, where we heard before about crewing, staffing shortages, and the airlines in the north do have fewer crew, it's true. But the idea was, well, we still want you to follow these regulations, but we recognize that you might have some other challenges, therefore you only have to pay half, because they really only have to pay half. And it's a very blunt instrument, but it's meant to cover a lot of categories and situations. So you could come up with a more fine-grained one for various areas of the, various carriers, various areas of the country. Then it gets complicated. Or you could say there's no difference. And unfortunately, we have this, maybe fortunately or unfortunately, we have this very practical rule, which is little airlines pay half, and that's a good way to split the difference between them and, say, an Air Canada. But it's now being attacked in the Federal Court of Appeal as saying we're making a difference between airlines, and that gets rid of our jurisdiction to have these regulations, because the Chicago Convention says you treat all airlines the same. So, it's a no-win. I don't know where to go with this.
There are other penalties as well that are different between large and, a large airline has to book, a WestJet flight gets canceled. At some point, they might have to buy that passenger an Air Canada ticket.
Yep.
That does not apply to small airlines, is that correct?
The regulations were just changed at the start of September. I wouldn't swear to that, but it didn't. It used to be that way. You're correct.
Okay. I guess my next question is again to you, Mr. Lawford. You're talking about reforming the system? I think. Do you believe that the current system, the current exemptions, perhaps, if I can call them that, or the airline being able to say it's outside of our control? Do you think if the system is reformed as you envision it, putting it in something like OSFI, or can those exemptions still remain? Do you have to deal with both the exemptions and the system, or will the system change that you're proposing eliminate the need to get into the exemption discussion?
I still think you have to fix the in the control problem, because that's a factual ground you have to establish, and the airlines will fight it on every case. So just take it away. Unless there's exceptional circumstances, it's all within your control. But for the other stuff, 80% of the claims are going to go through. And that's what I'm really here today to try to get, is just to get the vast, majority of delays and cancellations paid out quickly. And then, we should be fixing the control problem. But safety is a little more touchy.
Back to Mr. Lukacs, just on that issue that Mr. Lawford has raised, I'd be interested in your perspective. Do you believe that there needs to be systemic reform in the type of, do you agree with that? He agrees with you on the need to reform exemptions. Do you agree with him on the need to reform the way that these complaints or this compensation is adjudicated to more of a, he said parking ticket versus, basically a prolonged investigation maybe was the word. Do you agree with that? Can it be done that way?
I would say that in order to achieve that type of system, we need to change also how clearly the rules are written. So right now, to verify eligibility to a $400 claim, one needs 1,000 pages of documents, possibly, and legal arguments. In the European Union, typically the eligibility of a passenger to compensation can realistically be verified in a couple of minutes because it requires so little information. If the rules are changed accordingly, and if they are enshrined in the Act, not in some regulations, as they should be, as they were in the European Union, then the system might be amenable to a more fast-track process. Having said that, there has to be also provisions for hefty fines for airlines that break the laws and break the rules. It's not enough to provide compensations to passengers.
Thank you very much, Mr. Lukacs. Finally, for our line of questioning today, we have Ms. Koutrakis. Ms. Koutrakis, the floor is yours. You have 5 minutes.
Thank you, Mr. Chair, and thank you to all our witnesses for your very important and interesting testimony this afternoon. My first question is to Mr. Gradig. I want to talk a little bit more about reforms, and in your opinion, who should be consulted with regards to a potential reform of the APPR rules? And more importantly, how do we prevent airline lobbyists from having inordinate influence, but at the same time not creating rules that have unintended effects?
Thank you for the question. Great question. I think that what you're looking at is looking at a way in which we can have a balanced view of those APPRs. Right now, the way you hear it in the session this afternoon and going on for months, that we've all said that the airlines really had much too great a say in what these regulations ought to look like. The question you have to ask yourself is it worthwhile to have some other groups in that negotiation to temper the way in which the airlines are really looking at adjusting these rules? I think it's important that, and I don't know what the right mechanism is, and whether we basically have more consumer groups or more representation by organizations that you have around the table here today in those sessions, but it has been inordinate amount of influence by the airline industry in these APPRs, and that's got to change for the next time around.
Thank you. My next question is to Mr. Lawford. We talk a lot about, the process being somewhat difficult, and a lot of passengers don't end up, filing complaints. So for all the complaints that do not go to the CTA, and they go just to the airlines, what data do we have about those cases? Do we know if airlines collect them? And do they share it? And should they be required to do so?
My understanding is we don't generally have those internal complaint numbers, I'll call them. And I'll just note that in the banking industry, the regulations were just changed to require internal complaints to be logged and to be provided to the Minister of Finance, so that groups like ours and folks like you can keep an eye on whether the internal complaints are being handled, because the companies always claim that they're doing a good job with their own customers, so let's see it. You can also impose a standard internal complaints process, so they don't have different processes. If you're at WestJet or Air Canada, you can expect, say, 2 levels. and then you get referred automatically to CTA rather than having to ask, things like that.
And my final question, and this could go to any witness, everything is about dollars and cents at the end of the day. So I'm just wondering if any of you have information of how well funded is the CTA process compared to similar systems in the US or in the EU to address passenger complaints. If anybody has some information on that, I'd greatly appreciate it.
Thank you for the question. The Canadian Transportation Agency recently received, I believe, an additional $10 million funding, if I recall the figure correctly, and it needs to be verified. But this is not really a question of money, actually. This is a question of how that money is being spent and whether the procedures, the regulations are amenable to efficient processing of complaints to begin with. The other part is that whether there are processes to ensure that for each one complaint which is caught, there are 10 which are prevented by enforcement actions. And that's an area where the Canadian Transportation Agency is sorely wanting. We cannot have a police officer or an enforcement officer on each corner or at each airport. What we can do is that when violations are caught, there are such a severe financial consequences, like we have seen in the United States, $7 million fine, that airlines will think twice before they would break the law. But ultimately, the problem with the CTA is its lack of independence. We can give them as much money as we want. They will still not be able to do justice. We know that the CTA is having sometimes encrypted emails exchanged with Transport Canada behind the scenes, and they are not actually adjudicating matters and dealing with matters in a fair manner.
Thank you very much, Ms. Koutrakis. And on behalf of all committee members, I would like to thank all of our witnesses for joining us either virtually today or in person for our study on air passenger protection regulations. For those joining online, I invite you now to log off at your leisure. And I'll turn the floor as we do that to Mr. Strahl to present a motion.
Thank you, Mr. Chair. Appreciate that. Colleagues, you should all have notice of this motion from Friday. And the motion, I'll read it into the record here. It says that pursuant to Standing Order 81.5, the committee invite the appropriate ministers to appear with regard to the supplementary estimates B for 2022-2023. So I obviously would hope that my colleagues would want to extend that invitation to both the Minister of Transport and Minister of Infrastructure to appear.
Any objections from colleagues? Seeing no objection, the motion passes. And with that, I'll thank our two witnesses who are still with us and announce that this meeting is now adjourned.